All right. This session has been brought to you by Alta Claro. They're also the ones providing CLE certification for this conference, and we really appreciate them. So visit their booth. They have all sorts of things, including master classes and fun stuff like that. But finally, I'm super excited to introduce our speakers. We have, starting out, Susan Milloy, who is an intellectual property administrator at Lockheed Martin Corporation for 12 years. She handled both patent and trademark matters. And she was the patent and trademark database administrator for the CPI systems. We forgive her for that. Her responsibilities included training IP paralegals and payment of annuities, coordinating with outside counsel on maintenance and renewal, and all sorts of other things. Yeah, she's lovely, and we're glad to have her. Sofya Nadgorny is Associate Counsel of Trademarks and Domains at Warner Music Group, not Warner Media Group. Phew, got it right this time. She had worked for Nature's Bounty as IP counsel, and there she managed the company's IP portfolio through privatization, acquisitions, and integrations, all sorts of other things. She recently joined Warner Music Group. It's not as recent anymore as it was when I first got this bio. So Sofya, who shares a name with our support guru, they like to joke that they're going to start a band called Sofya, where they will craft melodies that deserve their own non-traditional trademarks, which you will have heard about at Ed's session yesterday. Their breakthrough single, It's in Your Docket, will be released in December. All right, Sejal Patel Richbourg is Assistant General Counsel of IP and Litigation at Shutterstock. And, you know, has a beautiful photo face, which is appropriate here. She's responsible for managing Shutterstock's global IP portfolio and their disputes. She provides counsel on a wide variety of intellectual property, marketing, advertising, and privacy matters. She's passionate about providing innovative business solutions for product, marketing, and content teams while strategically managing risk.
Ignore.
Okay. And finally, we have Lynne Boisineau, who's our moderator, who focuses her practice on trademark prosecution, counseling, enforcement, and licensing, as well as providing litigation support in the areas of trademark, right of publicity, and copyright. She's managed upwards of 4,000 marks at once because she's super talented like that. And after working for nearly a decade at large firms, she started Boisineau Law in 2018, and she speaks frequently about topics of interest in the IP community. All right, so thank you so very much. We are really glad to have you all. You will see me again later when I interrupt to give the CLE code, but otherwise, thank you so much. We're excited to hear from you.
Thanks for the introduction. We'll go ahead and just dive off from here. Let me advance the slides here. Sorry, I didn't have my cursor on the right thing. We went through the introduction, so that's great. Then we're going to kind of breeze through these first two slides because everything we talk about is going to be on the subsequent slides. So they just kind of set forth the general descriptors of in-house client position versus outside counsel. As you can see, in-house clients handle a wide variety of jobs and rely on outside counsel for the detail work. They have many internal constraints based on budget, internal teams, profitability, shareholders, and so on. So that can be tricky sometimes. And for outside counsel, they face some of the same pressures, of course, but also some different ones, such as balancing the need for billable hours with the client's budgets or, flat fees, et cetera, and learning how different industries work to better understand their clients' needs, staying abreast of different areas of law, current case law, et cetera, that would affect the areas they practice in. So let's move on to the meat of this. So with respect to the commonalities between in-house clients and outside counsel, I just want to speak on our panel to speak on some of the daily challenges that they face in managing their global trademark portfolios, and in some cases, patents and litigation on top of just the trademark portfolios, as well as I know sometimes in-house IP counsel even gets thrown into different areas that deal with employment law and what have you. So they got a lot on their plate. So the first question, and we'll kind of go Sofya, Sejal, and Susan, and I think we talked about that order, but obviously hop in if there's something that you're really passionate about or want to speak on. What makes your life easier in dealing with the high volume of matters that you handle? Receiving, lots of lead time up to a deadline, or communications from outside counsel only as the deadlines draw near? I know everybody has different preferences. And how does the timing of the filing of certain things come into play when planning your fiscal year budgets? So I know that's kind of a lot to unpack, but just if you could speak on that. Go ahead, Sofya.
I think just to start off generally, getting to know your client and their preferences from the get-go is super helpful. Instead of assuming what you think they might need or want, preempting expectations. So like using the budget example, if you know that your client has a huge renewal, like a portfolio that's coming up for renewal in the next budget year, and they do budgets like 6 months out, give them the heads up in case they need to bake it into their budget for the following year. Stretch out renewals if you can, depending on if their budget's like October or calendar year. Ask and establish those preferences. So using like the budget example for one, I think also because it's on the slide, the concise language and the specific language that your client needs. So for example, like with Alt Legal, I don't need to know when a U.S. application published or got registered, because I already have my daily email from Alt Legal with all of the links to the USPTO, et cetera. But if, let's say, there is a refusal, don't email me that there's a refusal, don't email me that there's an office action posted. Read it through, let me know like the big picture, and then if we need to discuss, we can discuss. I think like one of the other things that when it comes to communications is that, especially like with big firms, they give you like a novel treatise of here's everything that they could possibly think of, most of the stuff that you already either know, anticipate, or don't really need, and then they just stop the buck there. Like there's rarely that next step of, okay, so here's the suggested next step, here are options. And if you already know what your client's preferences are, when it comes to certain options, preempt that. If you know that your client's going to want to know how much each option is going to cost, preempt that. So along those lines. And then I think the other thing is, especially when it comes to like searches, and this is when you know your client's industry, if I wanted to do an artist name search, for example, and I would usually do, let's say, like class 9 and 41. But if you know there's going to be streaming, or if you know that there might be an element of merch to it, suggest, I also found something in class 25 for, potential merch opportunities in the future. Or if there's going to be streaming, here's a potential, citation or problem in class 38. So things like that. Sorry, there's a lot in there.
That's okay. Sejal would make your life easier with respect to those things.
Yes, this is a great question. I'll speak to the point of view of an in-house legal professional who manages a very broad variety of IP issues. So, at a small to medium-sized business such as Shutterstock, there's one person managing patents, trademarks, open source, copyright, everything. So we live in a day and age of information overload, and just as Sofya said, it's sort of unusable if we're getting a ton of information that goes really in depth on various legal issues that are maybe not the most pertinent to the decisions that we have to make immediately. So something that goes really far and is something that we actually specifically look for in outside counsel is counsel who are willing to get on our level and really figure out what it is that we are trying to accomplish, and then come to reasonable expectations surrounding what that communication looks like in relation to those projects. So for example, when we have to file certain affidavits, great. We know a year in advance we need to file them. But for a small legal team managing this, it's really not that practical to get that information way in advance. So we like to set those expectations with our outside counsel that, maybe a month before that window opens, maybe that's when we would want to be contacted. And then it's not that we don't want any information at all. It's just that we want information that's specifically relevant to what we're doing. So that might be, hey, I saw this article about X, Y, and Z in your industry. You might want to think about, how that might impact you, or maybe the direction that you would go. That goes way further than getting very in-depth information about things that are not super relevant to us. And I think that's all fine and easy to say. But, as a suggestion, I think it's really valuable to us when outside counsel actually meets us halfway in that conversation and asks us specifically what we want. I think a lot of outside counsel tend to default to the position of, we'll wait and see what our clients are asking of us, instead of maybe being more proactive, because we do have a lot on our plates, and sometimes it's not even intuitive to us to sort of, meet halfway. So that goes a very far way when we're approached in that manner by outside counsel as well.
Yeah.
So it sounds like, Sofya, you want a long lead time for your reminders, and that Sejal kind of wants not so much until she has to deal with it. Susan, how did you normally draw that balance?
Well, I think we were on a quarterly reminder basis, which worked for me, but I know that that's different for everybody. I think my the person who took over for me likes things a little differently than I did. So I think outside counsel just has to really communicate with the client and say, what do you like? What would you like me to do? How would it be better for you? What changes can we make that work for you? I think just keeping the line of communication open as to what the client likes is the best way to go.
Yeah, another example that I thought of was I get so many emails, and I think this is more ex-US than US, but I get emails like, oh, we found, there was a watch on this mark that might be a potential, opposition. And 80% of the time, it's completely different, unrelated goods. So it's this long email letting me know that some third-party mark published, but we don't even advise you, opposing it. I don't need to read that. And that's mentioned most in-house clients, at least if it's a big enough corporation, we already have our own watch notices. We already have somebody going through it. So it's just double work. But I know that there's some that aren't. So, just another point in getting to know your client and what their needs are. Some might actually really appreciate the FYI and a potential opposition, and others are just, I already saw this in 3 different ways.
Yeah, I think that most of my clients don't want to hear about something that's not even remotely in their industry, because you can't oppose every single thing that most people just don't have the budget for that, or the time, or the energy. And it just doesn't make sense, because you might have even social media backlash. It's oh, why are you cracking down on these people who don't do anything that's remotely like you? And no one's going to be confused. You can have things like that come down the pike. Okay. The other question I had written down under here was how. Obviously, most people do prefer flat fees to billable hours, but do you have any other alternative methods of keeping costs down, such as not to exceed, or where there's a project and the attorney needs to check in at certain stages and say, here's what the billing is, and now what do you want to do, and let you make decisions based on that, or et cetera? Is there any kind of, deviation from the billable hour or flat fee that works for you as well?
I haven't had, I actually just recently heard that there might, some law firms are doing a subscription-based model. I haven't had experience with that, although it sounds interesting. Most of my experience is, half billable, some flat, mostly flat rate. I feel like ex-US tends to be more flat rate, US tends to be more hourly. For me, it's just a matter of fairness. One thing to mention that I noticed some firms do, which immediately put me off, was if they're assisting with filings in jurisdictions that are not multi-class, and like it's all the same mark. It's just, 5 classes of the same mark. But you're sending one email about the POA, and you're sending one email about, let's say, all of them published at the same time. While then going and charging like 0.1 or 0.2 to every single one of those 5 matters, as opposed to, taking the total time and divvying it up properly. I've had that happen with a couple of firms, and I called them out on it. So I think it's more about fairness, and like, don't charge me for sending a publication, notification of publication if I already knew that myself. I feel like a lot of it's just common sense. Not feeling that you're being taken advantage of. But with regards to like when we have big filing programs, in certain instances, if I already know that I've worked with counsel and I liked how I've worked with them, I'll go to them and I'll obviously, get a quote and check with the business folks if that is okay with them. Sometimes I've, wanted to try out a different firm and see if there's a difference in cost. For the most part, I think they're fairly equal, but it really is a matter of like, I feel the more flat rate you have for pro forma matters like filing an application, the better the relationship. If it's something unique and I need really niche advice on, a really unique question, then obviously I understand that would be hourly.
Yeah, one thing that while you were talking that I was thinking of is that it seems like you do a lot of stuff in-house that maybe some other companies don't, because you're getting notified of all the things that are happening at the PTO via all legal or otherwise, and you're doing your own document, have you? But some clients don't do any of that, and they want the reminders, and it's I know as outside counsel, sometimes I want to make sure that I'm doing what's reasonable. Like I'm reporting each stage, because maybe some people would see that like not reporting that would be a lack of diligence on our part, right? So I think that maybe falls under communication, because I've even had clients that had in-house docketing, did their own work, but they still wanted reminders. They still wanted you to tell them everything because for whatever reason, maybe they just had too much going on and they wanted that double check. So I think that, again, it's going to probably always go back to communication. But Sejal, do you have any input on just different types of billing or things that you would be willing to try, like maybe subscription, even if you've never tried it, et cetera?
Yeah. So again, speaking from a sort of more IP generalist standpoint, I'm personally responsible for the budget of any of the matters that we have under the IP umbrella. So what I like to do is take this flexible approach. Like we sort of know when, the hourly rate makes the most sense. Versus maybe something that's better off being done flat rate. For example, if we know junior associates or something like that are going to be, working on a matter, then maybe we will opt for one over the other. I always really appreciate it when I'm able to communicate with outside counsel and say, we have X budget that we're looking at for the year. We anticipate these things are coming up. We know that, we can't predict everything, but within the confines of this, we think that past X number, we might want to work something else out. What do you have to offer us in terms of those various arrangements so that we can make sure that we're getting what we need to get done without, going over our budget or having to make hard decisions that will impact our portfolio. So that's what we tend to do. We have a number in mind, and once we exceed that limit, and Shutterstock has a smaller portfolio, I think, than a lot of companies. So we have to really be tight about the budgeting around it. And what I appreciate is when outside counsel is able to come up with flexible arrangements. So I've actually never been suggested the subscription model that you mentioned. So that's interesting to me, but maybe we'll do something like, a blended rate of some kind at some point if we feel like more junior people are working on something, or, maybe doing flat rate or flat fees, but with like certain caps for certain types of works and things like that. It's always great when we get those options up front and we don't have to ask them at the point where, maybe we're running over budget.
Yeah. Susan, do you have anything to add on that?
I've never heard of that.
You've never heard of subscription rate?
So yeah, what is a subscription rate?
It's sorry, you were muted at the beginning of your question. It's basically like, let's say, I would say, hey, I'll handle all of your trademark needs and questions and emails, unlimited even. but you pay a certain amount of money, or it's, this many phone calls, this many emails, for a flat rate of, et cetera. Some people like that because I think it kind of works out in the wash. Maybe the lawyer sort of, gets decent billing on for versus time on 1 month, but then a couple months maybe they work extra 10 hours over or something, and then the client kind of gets the benefit of that. But the nice thing for the client is that they have a set, $1,000 a month or this many dollars a month, et cetera, $10,000 a month or whatever, and they know it's going to be that much. And then the lawyer knows they'll make a certain amount. So it's just easier for both of them to kind of figure out what's going to happen throughout the year for budgeting purposes.
Okay. Probably works better for a smaller portfolio, I would think then.
Yeah, probably.
Yeah.
People that need a lot of hand-holding, I think, would like it more than maybe people who have their stuff on automatic pilot, like I know you did.
Right. Yeah, I think way too many matters for that probably to work for us. The flat fee was probably the most useful for us.
Gotcha. Okay, the last question I have under this is, and I think we talked about it a little bit, how do you handle docketing for your matters? Do you docket internally, and do you ask outside counsel to provide reminders? And, sometimes it's not just a monetary thing. Sometimes, I know, and maybe we'll ask Susan first on this one, but I know we worked together in the past, and sometimes would find errors, with a portfolio that has older trademarks. The laws change in various countries, and then sometimes, renewal deadlines would change and whatever. And we would catch a lot of things sort of proactively by working together to kind of, hey, do my dates match yours? And, on these quarterly deadline charts, and we were able to kind of save the day together on a couple things where maybe had we not been so proactive, it wouldn't have worked that way. So if you want to comment on that, and then we'll go to Sofya and Sejal.
Well, yeah, we're a corporation that's has a long history and a lot of historic patents and trademarks. Some of our trademarks go back to the 1940s. And there were files. They weren't in such great shape, but I think over the years, we, as renewals came due, we started cleaning things up, and we found errors, and which points to the value of keeping those old files. I know everything's electronic these days, and it's wonderful. But there is a value to keeping old files there. I remember one time, Lynne, we found an error that the foreign associate had wrong. And we finally cleared that one up. But yeah, I think, there is a value to having a human being going and looking at a paper file sometimes, so that, like I say, that was something that I did frequently. I think it's better now that we've cleaned my portfolio up, but for a company who's been around a while, I would say don't get rid of those old files. You may need them sometime.
Yeah, definitely getting a history of trademarks and what's going on, or what you license. Mm-hmm.
Right.
Yeah, Sofya, do you have anything
together sometime?
Oh, sorry. I've actually had a wide spectrum of experience with handling the docket. So at my older company, I came in and it grew by acquisition, which I feel like a lot of corporations, at least with the CPG or entertainment sector. So I came in and I was using CPI. And back then, it was really just a matter of like going on the respective country trademark offices, at least the ones that have the databases available, and like cross-referencing like that information, which was exceptionally tedious. And then when I came to Warner, they didn't have an internal docketing system. So when I set it up with Alt Legal, I pretty much imported an export from outside counsel, like the various ones that had various portfolios. And what's great, this is like a plug for Alt Legal, but I feel like it really made a huge difference where I plugged in the information, and with the smart status, it really gave me the ability to be, if my date that was imported matched up with the Alt Legal smart status, I knew I was fine. But if there was a discrepancy, then I would either look it up if the database was available, or I just reach out to local counsel to have them confirm like which is it. Like I know Austria has some weird new law where like it was all wacky. So again, I think it's like one of those things where it depends on your client. I know that Alt Legal has an option where you could have outside counsel docket directly in Alt Legal, which I think is actually really great and a huge time saver. Other ways that like I cross-reference or at least make sure that our dates are pretty good is usually like when I came into Warner, I would email outside counsel, and this is more like ex-US based, but even US, and be like, okay, here's the docket, like that respective docket for that counsel. Here are the chart of trademark particulars, and have them review it, input it into their docket. And usually, if they notice a discrepancy, they'll let me know, or I'll have like the annual renewals that I'll just export the renewals due for the fiscal year, and then I'll start emailing each of the respective ones to outside counsel. And if they notice a discrepancy, say that, well, this actually isn't due until another 3 years, or they'll say, this one actually was never renewed 10 years ago. It's a self check. So it's this wide spectrum. I feel like it kind of also depends on how robust and how good your docket is to begin with.
Sejal, I know you have a smaller portfolio. Do you have any preferences or oddities, I guess?
So I have been in the fortunate or unfortunate position of having to sort of redo our docket twice, I guess you could say. So this is where I don't feel like I have enough time to talk about how much I love Alt Legal because as a small portfolio owner, and again, we have a really small team that can be dedicated to this work. The smart dates are absolutely crucial to us. And, we've picked up new counsel, and we're sort of more in a state of change at the moment and sort of evaluating what we're doing. And we're actually not fully even updated on our trademark docket yet, but I know that I can trust the dates in Alt Legal, and I have a resource to go to sort of check whether those are correct, which I'll cross-reference with our outside counsel. And I will say that we do use our patent counsel as collaborators on the platform, so they help us docket our patent portfolio, and that's something that we're planning on doing with our trademark portfolio. So that ability to collaborate on one platform instead of sort of cut out the middle work of emails or cross-referencing via email is absolutely crucial to us, and it's a reason that we love Alt Legal so much, actually.
Great, glad to hear it. Okay, let's move on real quickly to communication. I guess I just want to check my time. We're about halfway through, and I think we talked about this a little bit, but what is your preferred method of communication from outside counsel, and how do the different styles make your job harder or easier? So, for example, I know when I'm on the receiving end of a foreign associate email, and Sofya kind of talked about this, that just reads like a treatise. It's like very dense and super long and unwieldy, and I have to dig to try and find some kind of recommendation, or there isn't one. It's just kind of on the one hand this, but on the other hand that. It's super frustrating. And my clients don't usually care about all 5 options that they have, right? They want to know what's the most likely to work with the least cost and the quickest resolution and the fewest headaches or surprises. They don't want to be embroiled in cancellation proceedings, invalidation proceedings, et cetera, when maybe just refiling, like let's say for China, for example, it's like maybe refiling for the logo instead, or something else that might work that would get them a mark that they can put on the goods and sell in China and work, basically a workaround. They don't want this huge thing of all the possibilities in the world that might cost $1 million. So, Sofya, I know you have a lot of passion on this topic. So maybe you can speak to that first, and then, but leave enough room, enough time for everyone else to come.
Okay. All right. I'll try to be succinct, which is kind of the theme. So business people don't care about the legal reason as to why whatever it is that you're suggesting is good, suggesting. So too much legalese, cut it out. Also, another big thing with corporate clients is that they don't like no, A lot of the times this could be possible if you did this, this, and this. And like majority of the time, they don't want to do all of the extra stuff that could make it possible anyway. So it's like saying a no without actually saying a no. But at least it's presented as like, here's an option. Here are the mitigation suggestions that you could apply in order to get what you want. And that's where knowing your client's goal is so important. Like if all I care about is use, or if registration is my main priority, you angle your advice towards that goal. Instead of kind of giving me all of the options for all of the potential goals that I might have. So like a lot of the times, ask what, is use or registration more important? Kind of what we said before with like the analysis, like you could give the analysis, but then go into like, okay, how do I apply it? Like what can business do with this? I almost feel like I'm like, okay, top 3. And yeah, it's really just a matter of just preempting and knowing what the goal is. I had an artist name search once, and this is such a great example. I had an artist name search once and this was like when I had just come into Warner and I wasn't really comfortable with artist name searches because they're so unique. I asked one big white shoe firm to do a search. And they had your prototypical, like this is too risky, there's this other user, period. And then I asked another white shoe firm that we worked with, and they were like, this is defensible. So you could use it. There's risk, but it's defensible risk. And then I asked a boutique entertainment law firm to do the search. And it was like the perfect advice. It laid out the practical risks and it didn't just give me like the legal risk. So with communication, I guess like my summary really would be if you know your client, know what their goals are and advise to those goals.
Okay. Sejal, do you want to add on that?
Yeah, my thoughts really echo a lot of what Sofya said. Understanding, really taking the time to understand what it is that your client's needs and goals are. To me, it's like the top thing that you can do to sort of help those communications geared towards what needs to actually be done. And a great example that I have of this, or I guess an example of my company, we had a trademark issue with third party, and a firm that we were working with was like, okay, we can do an investigation on this website, we can like get the police involved. Well, we're a digital product, so our concern as a brand owner is not the same as maybe someone who's a company whose trademark might be used in counterfeit goods or something where it will actually detract with a very large impact to revenues. We're sort of different product. Shutterstock is licensed content that gets incorporated into other things. So spending hundreds of thousands of dollars on, enforcing against a trademark infringement that doesn't necessarily, detract from our revenues in the same way as another business might. It's completely incongruent advice and direction for a company such as ours. So, I think I'll echo a little bit again what Sofya is saying about, understand our business. And then also we don't need every single option. And I understand that outside counsel does this because it's a little bit of a CYA thing. Like, we want to present all of the options, but really the quality of the legal advice is when it applies to what we're actually trying to do. I think we can all look up sort of, all of the different legal options we have, but what we're really looking for is a business partner to help guide us into the direction of our end goals.
Gotcha. And then Susan, did you have anything to add on that as far as getting
I
advice?
really totally agree with what both of them said. And the most important thing is to know your client, know their goals, know their what their priorities are, and then you'll know what it is they need to hear from you.
Okay, let's move on because we want to stay on track here. So this slide has to do with deference, and it kind of ties into communication, but slightly different. Let's start with big firms versus boutiques and the different styles that they have in terms of, responsiveness, the type of advice you receive from both, et cetera. I know that some companies like to have different firms for different things. So maybe like some clients I have, they'll use me for trademark prosecution because it's low cost, flat fee, et cetera. But they want a big firm for cease and desist letters. They want a scary letterhead. They want a big firm for certain types of litigation, or just a mid-sized litigation only firm that's maybe located in the Midwest and has better rates or something than a California, New York firm. And so there definitely is, I think, a difference in style, how a big firm lawyer feels about the portfolio. Like, for example, Shutterstock might be a huge portfolio for someone who's a solo practitioner, and they would be super jazzed to get your work and be super deferential and whatever you guys wanted, sky's the limit. But maybe on the flip side, you felt like you were the little guy that didn't get as much attention as you should, or maybe they didn't care as much as they should in coming at you. So I just wonder if you guys want to speak on that and what your experience is. So Sofya, you want to? Oh, I'm sorry, Sejal, you want to? I see you're unmuted. Whoever wants to go first.
Say that, you go first.
Okay, I'll go ahead. Yeah, and I hate to break it up into big law firms versus boutique firms, but I really think for our company, this is where boutique firms truly do shine. In the past, we've had experiences with firms that have a lot more clients where sometimes the advice that was given was a lot more generalized. Maybe the specific business issues that we were concerned about weren't sort of being translated as well, because maybe, the attorneys we were working with might have had a lot of other clients on their plate. And so therefore we weren't getting that tailored approach or advice that we're looking for. So that sort of ties into this topic of deference, because for firms like that, I didn't feel comfortable being like, okay, you just make this decision on our behalf, because I didn't necessarily trust that they understood our business fully. And, I had one experience where we were working with a reputable larger firm for a long time. And I just didn't feel like I could trust the partner that we were working with to sort of help us or just make those decisions on our behalf. And I didn't feel like they truly understood our business. And so we sort of worked our way out of that relationship into a smaller boutique firm that we're really, really happy with, because we feel like they understand our business, and we can, we defer to their suggestions on what to do because we know they understand where that line is at. And this also ties into communication a little bit, because we did communicate with them like, X, Y, and Z decisions, we're totally fine if you go ahead and do that. We trust you. We know you understand what we're thinking about. And then after a certain point or a certain complexity of problem, that's where we sort of want to be, given the very basic lowdown of what's going on, and, do you want to do X, Y, or Z, and, go from there.
Sofya?
Oh, there I am. Yeah, I have to say, like, I rarely use big law. At my first company, we really didn't. We did mostly in-house, and whatever we needed, outside was boutique. When I came to Warner, the two firms that they were mostly working with that handled the docket were two big white shoe firms. And it was my first experience, like nitty-gritty experience, and it was awful. Like awful in the sense that what I was used to, in the sense that, I couldn't understand why every single time, a big white shoe firm would file an application, and like this was ones that I had inherited, like, why is there always an office action on the specification of goods? Like, you guys should know by now, like, what can or cannot get through. So I felt like it was, just trying to almost like not on purpose, but there wasn't, an effort to try to make sure that the application was as smooth as possible. Or going at, like, when it came to specimens, trying to really understand what we're doing and getting the right specimen as opposed to putting it on us. And like, I don't know what the examiner specifically might want, or like, before Class 38, they would accept, a streaming from YouTube, but now they no longer accept streaming from a third party. It has to be directly from your site. Like, those nuances is what you would think that they would be there for. And it would just literally be an office action every single time we use them for the response. The only really upside in my experience with the big firms is that it's really the history. Especially like when I came in, like I didn't know all of the agreements or the licenses or, certain terms, et cetera, when it came to certain marks, or if there was some sort of coexistence agreement or settlement agreement that was agreed to that I had no record of or knowledge of. So I feel like the biggest, they're a really big resource when it comes to history if they've been around for a long time. But as far as like, UDRP, I have UDRP Counsel. With regards to searches, like if it's an artist name search, I like to go to a boutique entertainment firm counsel. It really is, you almost kind of find a niche for each particular thing that you need. And that's where really the boutique firms shine, at least for us. And yeah, that's kind of how I pick mine.
Okay, Susan, do you have anything to add on that as far as difference?
No, not really. I mean, as a large corporation that had a large portfolio, very large, we always use large firms. So I don't think a boutique firm was ever in our sites.
I think you did have a couple, not just your company, but other ones that are large. I think sometimes they do have rare sort of small, especially patent law firms. Like maybe they like one patent drafter who.
Well, that's for the patent firm. I think that's a little different. Yeah.
Yeah.
Because the patent firms tend to specialize in different fields, and so yeah, you might use more a specialized firm, a boutique firm for certain
software technology or something.
Certain technologies, right.
Okay. Let's go on to the next one because I want to stay on track here. As far as responsiveness goes, for me personally, I've had some clients that are super laid back and, you just get back to them when you get back to them, and others that expected immediate responses. And during the initial trial period where we were working together, would actually literally time me to see how quickly I responded to things, right? And now, even factoring in time differences. So, I think there's a broad spectrum of what people expect, whether it's one same day, 24 hours, or, as long as you acknowledge it, like my foreign associates a lot of times will say, received with thanks, but I don't get a substantive response until like a couple days later, et cetera. So just wonder how you guys set expectations on those and what you prefer. Sofya?
Hold on, there we go. I actually am pretty laid back. I feel like it's rare to have anything that's like, oh my God, I need a response now. So my default, and most of our outside counsel understands, my default is like, if I send you the question, unless I tell you it's urgent, or unless I tell you there's like a huge deadline, there's just an understanding that, I want to say everybody pretty much responds within like 24 to 48 hours anyways. So I don't feel like I've had that big of an issue with it, but I do feel like this is just another point for communication, knowing your client's preferences. Ask, like if you ask your clients in advance instead of just anticipating or assuming, you'll know what their expectations are. Because I'm sure that there are other clients where the expectation really is, I expect an answer within 15 minutes. Or at least acknowledgement of the email that you got it and then you get back to me with the next amount of time.
Okay. Sejal?
So for me, it's a little bit more dependent on exactly, what the subject matter is about. And if there's something that I need to do, then I want a little bit of lead time. So if there's, I'm supposed to, get something that needs to be notarized or get some sort of specimen. Again, it's nice when outside counsel understands that I'm the only one doing it. So if you could please give me more than a week or two, that's always helpful. But in terms of wanting answers back, I actually, I think a lot of in-house counsel have the tendency, or at least I do, 5 p.m. I'm like, I know I need to ask outside counsel about this. I need to make sure I at least get this question out there before, maybe I turn in for the weekend or something. I like to actually just let our outside counsel know, don't answer this over the weekend. And I guess you could say I'm probably in the same more laid back camp. I don't expect anybody to be responding over the weekend, but if it is something that, is urgent, I'll indicate that it's urgent, and hopefully, our outside counsel can read between the lines. But overall, I think I'm more like Sofya. Things don't need to get back to us, like that day or that hour or anything like that. But on the flip side, if it's something that's required of me, then I kind of want a little bit more lead time so I have time to plan for it.
Yeah, just another thing that reminded me when you mentioned it, like we had counsel where I had like 3 days notice before the deadline to appeal was happening. And mind you, like in the UK or the EU or something. So I was like, why am I getting like 3 days notice? Like your outside counsel, and it was through one of the big firms in the US. So I told them, I was like, your outside counsel should be sending this much sooner to you. And you, if you get it, knowing that, I only have X amount of days, like should be getting to me much sooner, where we shouldn't be in a position where, you had, I think I'm like at least 2 weeks, I'm getting 3 days.
Yeah, I agree with that as well. One thing that we're pretty laid back, but one thing I don't love is, we need this response within a week, but we can file an extension, for another 6 months. And that's still an extension we're paying for. And it kind of makes me wonder, like, well, on, your docketing side or whatever scheduling you're using, like how much are you actually paying attention to our portfolio that it's coming so late in the game? And I realize in the larger scheme of things, it will get done and we'll be able to get an extension, but it does kind of rub me the wrong way when that's relied upon heavily, because it makes me feel like, they can, spend the $300 or whatever the extension fee is, and that's fine. So yeah.
That also reminded me of a lot of times, especially when it's, if it's an email or communication based on like an opposition or cancellation system of enforcement, it's so helpful to let us know the types of evidence that you may need to help us in making the decision. Because it's, if it's like the EU and they have a really, they have a pretty strict threshold on the types of evidence that's going to count. I want to know that and see whether we have it or not. Because I might think like, we sell albums in the UK, that should be fine. But EU really wants to see invoices, and I don't know if I'm going to get my hands on invoices, or how much time do I have to get my hands on invoices. And then the other thing on communication that I just remembered, because it was all in the same thread, super helpful when counsel preempts and lets us know chances of success in like percentage form. Business loves that format. I love that format. It really lets us be able to communicate like, above average. What does that mean? Like, is that like 51 or is that like 65%, So whenever it has to do with like an enforcement action, including that type of information is super helpful. So I know it's like a side note, but I remember it was really helpful.
Yeah, I agree with you. When I have foreign associates write to me and it's like I have to go back and forth 3 different times. Like, now I'd like to know how much it costs, and now I'd like to know what the chances of success are. It's like, can you just tell me everything at once?
Yeah.
Susan, do you have any further comment on responsiveness, etc.?
I'm sorry, let me turn my, yeah, it's on. I really don't. I pretty much agree with what they've said. It depends on what the subject is and how urgent it is and so forth.
Well, and as a paralegal, how it is to your boss.
Right. Like, and I don't know if this is the right time just to mention, I know we talked about this before, Lynne, you and I, as a large corporation, we have a lot of business units and a lot of different people that outside counsel is communicating with, and they all might have different preferences. So some might need a response on something that you don't think is real urgent. They might want a response immediately. Others are more laid back. So again, it goes back to that communication. Know your client, know their preferences, know what they want.
Yeah, in those instances where it's a really big client and I have tons and tons of contacts, I usually just make a cheat sheet chart. Who wants what? This person only wants once a month. They don't want to, they just like dump all their stuff once a month. Here are all the letters from the last month, and somebody wants it in real time. It's like, I just put all those in there because I don't even try to, memorize that. I just make sure I check it all the time and make sure I'm doing the right thing. Okay, we're going to go real quickly. Go ahead.
Sorry about that, Lynne. It is time for the CLE code. So get out your pens and your paper. The CLE code for this session is 6P That is 6 people value love and emotion. Whatever. 6 PVLE. Okay, carry on.
Thanks, Bree. I'm going to skip these next 2 slides because we've already sort of talked about them ad nauseum about, listening to hear true objectives, making sure you really know your client, what their goals are, et cetera. And then, oops, I'm having trouble. Learning the client's business. We talked about that too. But I think that everything else kind of falls under, we got just a few minutes left. Well, everything else falls under hiring and firing. So what prompts you to find new counsel? And what types of things do you seek? What pet peeves do you have as far as like double billing or billing you for donuts during a meeting, et cetera? Lack of communication, failure to adhere to your guidelines. If you give guidelines back to the law firm and say, these are all the things that need to be met and they're just not meeting them, go ahead and just throw in there. We've got 5 minutes left. So just hit me with everything, 2 minutes each, like the quick and dirty of what drives you bananas.
Okay, so quick and dirty. Hiring. I have to say that pretty much all of my hiring I've done through word of mouth. I haven't really sought out new counsel. So to that extent, the better relationships you have with your in-house clients, those in-house clients talk to other in-house clients and you get better recommendations. And then as for firing, I thankfully haven't had to fire anybody other than one firm. And that was for the billing practice that I had mentioned, which was a huge pet peeve. The only other thing, and I think, we've kind of discussed this in general, is that, there's no official firing. It's really phasing out. If I don't like how you did my searches for the first couple of times that, I tried you out, I'm just not going to use you again for searches. And then if I don't really if I feel like you overbilled me on, I don't know, a coexistence agreement, I'm just not going to use you again. So it's really not so much firing as it is phasing out. So if you're noticing that, engage with your client, try to see what they're unhappy with and to see if you could maybe fix it. And then the only other pet peeve that I haven't already mentioned is invoicing. Any way you can work with your client to make invoicing simpler, do it. I get monthly stacks of huge invoices that I have to go through, and then sometimes I feel like I have to check them against the previous month's invoices. Just work with the more you can save us time, the better. That's my spiel.
Yeah, saving time is definitely at the one of the top factors that we look at when it comes to hiring, and I won't say firing. We'll phase out firms if we feel like we're not on the same page or they're not sort of meeting our expectations. Following our outside counsel guidelines. So again, when we're talking about billing, if we're seeing that on our invoices, it's a junior associate ran something by the partner for review, and then you're billing us 0.2 hours or whatever it is. That's something that, we'd like to say once, hey, that isn't consistent with our outside counsel guidelines. And then if it keeps happening, it's okay, we don't have time to chase our firms to make sure they're compliant with our guidelines or sort of doing what we need them to do. And then the other thing is just a basic understanding of our business, which I know I've said so many times, but if it feels like we have to do so much more work because at some point in the link, the chain, there's a link missing of really understanding our business, and that's not worth our time, quite frankly. And in terms of how we find firms, it's word of mouth, and we do sort of an RFP process where we give some sort of problems that are pertinent to our business and try to get a feel for how potential law firms might solve those problems. And I personally love articles when people publish articles on LinkedIn or their sites, and I'm okay, I feel like they understand this area and they get it. That's something that we personally look at as well.
Great. Susan, do you have anything to add on that? We got to unmute you. There you go.
Unmute me. Not really. I was not the person who made that decision. We did hire and fire a couple of times. It was the IP Counsel's decision. I did have to do the dirty work, though. Don't forget your paralegals who have to make the transfer from one firm to another and are responsible for collecting and comparing and making sure that everything transfers properly. But yeah, that's about all I can say about that. It's not a comfortable experience.
I imagine that sounds terrible. So I think we're almost out of time, and Bree, correct me if I'm wrong on that. But I did have one question here in the chat box, and I'll answer it based on mine, and then everybody can kind of say the last thing. It says, provide an example of what a small boutique did to successfully solicit business from a larger company, and if such, how such a small company may be invited to respond to requests for proposals. So for me, I working in a big firm, I had lots of foreign associates, and so I kind of was on the in-house counsel side of it for some things, and I did have like a large law firm in a country that I won't name, who I was sending them probably 20 grand worth of business every month, 20 or 30 grand, something like that, a ridiculous amount, or, a decent amount. And they ended up needing something in the US and wanted me to do something. And so they became my client. And whatever it was some small project that, I don't know, it's probably under $1,000. And they were fighting me on the invoice. And I kind of thought, we're sending all this work your way. This is how much time I spent on it. This is how much it costs. When you're getting a big firm on the other end, that's what you're getting. And it really left such a bad taste in my mouth. It was like that, coupled with a couple other things, that I sent the whole, how they handled it when I asked them, hey, I gave some pushback and said, hey, look, we're sending you all this work and this is legit and blah, blah, blah. They gave me pushback, and I said, forget it. I pulled the whole portfolio, which was a lot, and gave it to a boutique firm in that country, somebody I'd met at the International Trademark Association annual meeting. And that person was super grateful, very sweet, great, great service, great everything, great pricing, and was incredibly happy afterwards. So anybody else wants to hop in with that kind of thing, an example where a small boutique, won the day and how they did it, that'd be great.
So for my example, it was when I first came into Warner, and it was like the artist name search example, where I feel like that's such a specific kind of search, and I wasn't getting what I wanted from the firms that were doing it for Warner before I came in. And oddly enough, who I ended up using was a small boutique firm in California, and I was working on a completely different matter with one of the labels, and we had a call with the not opposing, but it was the artist's attorney. And I thought he was so great. Like, he was pretty good on the call that, like, I was like, why don't I try him out for an artist name search? He is already working with artists. So like, outside of those, like, kind of like by chance, I can't say that I have a specific, it's really word of mouth / just kind of being introduced to by somebody else who you already know in the business. I can't say like I go and like search the internet for like music attorney for artist name searches. And then, yeah, that was pretty much it. And then for soliciting from a big firm, I have to say that like all of the work that I've slowly been taking away from the big firms, it's really to firms that I'm already working with. Outside of the example that I mentioned with like, artist name searches, which is so niche and isn't, general to trademarks. It's kind of who you're already working with or who you've already built those relationships with.
Yeah, it's funny you said that. Oh, sorry. Are you hearing that echo? I don't. Anyway, it's funny you said that because I actually got hired as local counsel by an opposing counsel one time. We had done a litigation matter. We were able to get it settled fairly quickly and amicably. And he thought of me when his client needed something in California, or he heard, whatever. So I think I actually got two things from that gentleman. So like, you're right. They see your work and it speaks for itself. I'm sorry, go ahead.
Company, like the litigation in-house attorney did some personal matter for like the GC, and the GC liked how she handled that, like, I don't know, traffic ticket, whatever it was, like for her, she got hired for like the in-house position. So it really is like you never know when your next, opportunity might be.
So I'll offer an sort of like alternative way wound up hiring boutiques. Again, like trying to just search for a firm that will do what we want is sort of, it's like an exercise in futility. Trying to find them. And of course, we're all getting a ton of marketing emails, right? LinkedIn requests and stuff like that, like for people who could potentially help us, but we're not sort of sure whether they fit whatever it is that we need. So one thing that I think is awesome when firms do, and I've found valuable and worked with some of these firms, is, maybe we're working on something related and they're sort of in that nexus, like what Sofya and Lynne are talking about, of like people we've worked with, or maybe it's completely random. We'll get an email where it's like, hey, we noticed X, Y, and Z issue. It seems like you have only so much time to respond to this, and we're just letting you know, sort of showing like, oh, we're kind of like monitoring, or we know we're on top of sort of your business and, an opportunity for something that needs to happen, or, an issue that seems like it hasn't been addressed. It's pretty tricky because, that's a lot of time that you'll be spending, I think, on trying to figure out like, things that maybe companies have missed or something like that. And of course, we'll have monitoring services and stuff like that. But at least in one case, there was a firm that was like, hey, we noticed X, Y, and Z, and the deadline's coming up, and it doesn't seem like, there's anything in place to respond to it. But if you need help, this is actually our area of expertise. Like, here's where we've done all of it. We wound up using that firm and still use them to this day. So,
okay, real quick, before we move on, CLE code one more time is 6PVLE. That's 6 Peter Victor Lisa Elizabeth. Okay, we have about 5 more minutes, so carry on. There are more questions here in the Q&A or in the chat.
I did want to say I remembered one unique way that, so the entertainment firm that I picked up for the artist name searches, which I then use on other stuff. Anyways, I guess he was like monitoring cases in California, et cetera. And then one time he emailed me, he's like, hey, I noticed that one of your subsidiaries just got served, did like a very, short analysis. And he's like, if your litigation team is interested, like, I'd appreciate if you forwarded my name or put my name in the hat and stuff. And I thought that was such a classy way of doing it. Like, I had no problem. I forwarded it to the litigation team in case they were interested. I don't even think they knew yet, like their attorneys or whoever it was, like didn't even know that they got that it was filed. And I feel like that really put his name in their memory bank. Like, I don't know if they use him or they will use him, but I thought it was a really creative, classy way of soliciting business. So if you're already working on like something in the trademark with a trademark in-house attorney, and you might want a litigation angle, like try to slip in the litigation angle.
One of the questions in the chat box is, do outside counsel attorneys that transfer to in-house counsel role perform better or worse than their peers? If any of you could speak to that, you can kind of hop in. I'm going to mute myself to keep the back feed out.
So I think this is a great question because I'd love to hear what others have to say on this, but I view it, law firm attorneys and in-house attorneys, being totally different types of attorneys. When you're in a law firm, you want to make sure that you're 99% correct, that the client is, the risk threshold is super high. You want to make sure that you're giving advice that doesn't get your client into trouble, as it were. They're meeting their deadlines and all of that. And I've found that in-house, the threshold is a lot lower because you're trying to balance business needs and pressures within the company for getting things done. And so that risk threshold is a lot lower. So I personally worked at a really small boutique IP firm for a year before going in-house, and I've been in-house for 8.5 years. But I do find that it is a steep learning curve if you're coming from a law firm into in-house, because recalibrating your mind to sort of think about the business needs and not be so focused on, the black and white of whether things are, a risk or not a risk, is a very, very different type of practice. So I think that's a great question. And I think it can be done. It just really depends on your personality type and whether, you're interested and passionate about those business values, maybe, more so than adherence to legal principles as much.
I couldn't agree more. I always felt like the attorneys who came in to in-house straight from having, from experience, they had a lot of like bad habits to break. Whether it was just like how they communicated advice to the business team and learning that, it has to be business-minded advice, or just how they wrote emails, like really long emails. And then the other thing I found that they struggled with, and it's not even law related, they usually come with like a lot of support staff from like a firm. You always had a paralegal do X, or you had a secretary do Y, and a lot of them I feel like had a tough time adjusting to like, you have a lot, you mostly do everything on your own. Like if you're lucky enough to have a paralegal or a secretary, that's great. But like, I know like at my former company, like we did everything, meetings, calls, like filing, etc. So again, what Sejal said, I don't think it's impossible, but I do feel like it's a steeper learning curve and just like breaking bad habits from a perspective of like what business needs.
Okay, I think we are pretty much at time here. We maybe have 1 minute. I don't know, Susan, I know some of the people where you worked came from big firms and then ended up in-house, and I didn't know if you noticed a difference, but if you want to take 1 minute to answer that, and then we'll kind of break off here.
They were very tough on the outside counsel. The ones that came from outside knew what to expect and what should be done and how it should be done. And I found them very tough on outside counsel. I'm not sure if you found that, Lynne, when you were working with us, but
no comment. Anyway, I think that's about our session, and thanks, Bree, for giving the code. And if anybody has any residual questions or things, you should be able to reach us via the Alt Legal platform or via email, or you can reach me on LinkedIn or whatever, and I'll try to get you an answer if there was something that wasn't addressed. But thanks, everyone. Have a great day and enjoy the rest of the conference. And thanks, Alt Legal.
Thank you so much, panel. We really appreciated it. And I think that the audience got a lot from that. So thank you so much. Coming up next, we do have a break right now, but then at 1:40 p.m. Eastern Time, we have 2 sessions. First of all, what you need to know about the USPTO's post-registration audit program, and culturally relevant representation. Both amazing and wonderful sessions with great speakers. I'm super excited for both of those. So when it's time, please go to the schedule page and choose which session to attend. Thank you all so much for listening, and thank you to our wonderful panelists. We really appreciate your candor. So thank you.